Hey everybody, welcome to another episode of Fighting Foreclosure. Foreclosure Help 777. I hope my videos are helping you understand things a little bit better so that your fight is worthwhile. Today we're going to talk about how to file a quiet title action in court. You're going to be the plaintiff and they're the defendant. If you file first, before they can file foreclosure, then they can't file foreclosure if you have a complaint already in the court system. This works for both judicial and non-judicial states. And for non-judicial states, you just go to the court and you file this, then they can't sell your house while you have a case going on. So let's talk about how to do that, okay? This is going to be real helpful to a lot of people. As you can see, this is the cover sheet, which they gave me the case number there, which is 2012 SU 001-845-93, and the date I filed it, Monday, April 30th, 2012. Seems like a long time ago, doesn't it? Anyways, and you can see the parties, they've pretty much filled it out. Quiet title. I think I paid like $300 or something like that. The first page you want to have is called Notice to Defend. You've probably seen these in other lawsuits, maybe not, but you can get these Notice to Defends. You could probably find it at your court website, probably has these, or you can look at other cases to find them, but they're pretty straightforward. You just want to use the caption at the top, putting your name, the defendant's name, the file number, notice to defend pursuant to PA Rule of Civil Procedure number 1018-1. Now, if you're in a different state, you'll just have to look that up and put whatever correlates with your state. But they're pretty much all the same as far as, what they say here. You've been sued in court and you may wish to defend yourself. You should take this paper to your lawyer at once, kind of stuff. Well, you know what? The banks probably have their own legal department, and they probably get a few of these. So, anyway, the first page is the complaint, obviously. It's a typical heading. Use a good word processor program. I use Microsoft Word, or I use Open Office, which is like Word. And it's free if you don't have Word. So you can get Open Office online. And now comes plaintiff Lorraine E. Souders pro se and complains of the defendants and alleges as follows. You start off with one, and you have to number these, by the way, when your complaints, so that when they file an answer, they can say number 1, affirm, number 2, deny, or whatever they write for answers. So make sure you number your complaint. So the first is myself. I identify myself as the plaintiff and my address. And defendant is Bank of America, formerly Countrywide Home Loans, etc. And their address. And I also sued defendant Bank of New York Mellon, and purports to be the holder in due course and trustee for the certificate holders of Schwab's Inc. Asset-Backed Securities 2007-12, and is a debt collector as defined by 15 U.S.C. Okay. Next page. Has a principal business. Okay, that's their address, 101 Barclay Street. You have to look up these addresses online to make sure you're sending your complaint to the correct address. I also sued MERS, Defendant Mortgage Electronic Registration Services. And I know that they have a principal place of business in Reston, Virginia. So I sent that copy of the complaint to them at that address. Any allegations about acts or any corporate or other business defendants means that the corporation or other businesses did the alleged acts through its officers, directors, employees, agents, and representatives while they are acting within the actual or ostensible scope of their authority, whatever. Anyway, I basically found information that I wanted to share with the court about the fraud I found in my case. They were aiding and abetted the other defendants, course they did. Jurisdiction and venue. Basically have to say, you have to have that on your complaint. Jurisdiction means what is the court in. This is the state court. Real estate settlement procedures. And even though the FDCPA is a federal law, the state also has their own. Venue is proper in this district because all defendants conducted business in Pennsylvania, and the subject note and mortgage was executed in Pennsylvania. Most quiet title actions should start in the state court anyway, because that's the proper court. Factual allegations. Okay, well, here we go. This is what you're going to say on your complaint. You have to have your own, I guess, but these were my factual allegations. On June 26, 2007, plaintiff, that's me, executed an adjustable rate note and mortgage, refinanced with the lender Countrywide Home Loans for $120,000. A copy of the note is attached hereto and incorporated herein and marks Exhibit A. And then it says the plaintiff went to the York County Register of Deeds office and discovered that her mortgage was assigned on October 14, 2011. The mortgagee, MERS, assigned the mortgage to Bank of New York Mellon, trustee of Schwab's 2007-12 asset-backed certificates, incorporated herein and marked Exhibit B. Okay. And MERS is not allowed to assign mortgages. We know this. This is law. The plaintiff suspected fraud because, according to the trust of the Schwab's 2012, the prospectus on page 7 says that the cutoff date for the mortgage assignments to enter the pool is August 1st of 2007. From the Securities Exchange Commission's website, incorporated here and marked Exhibit C. The plaintiff's loan number was verified as being listed in the Securities and Exchange Commission's website and converted into stock. It is then sold to investors on Wall Street. Once the loan was securitized and converted, it forever lost its security. MERS making the assignment to the trustee after August 1st, 2007 is a violation of New York law, which is true. The plaintiff is questioning the legitimacy of the mortgage and if there is a break in the chain of title. If the mortgage was never correctly endorsed by all parties according to the trust pooling and servicing agreement, the mortgage becomes null and void. Also, if the mortgage is separated from the note, it becomes null and void. The law of 1871 cannot separate the note from the mortgage. There is no evidence that Countrywide endorsed the note to anyone or that the mortgage was properly assigned to the now purported holder. In due course, the Bank of New York Mellon. According to New York law, the note would be put out of eligibility. See Ibanez versus Wells Fargo. Massachusetts Supreme Court. Okay. Defendants fraudulently concealed their wrongdoings and prevented plaintiff from discovering their cause of action. Plaintiff has been injured by the fraud by the defendants and has maintained in ignorance of it without any fact or want of diligence or care on her part. Defendants made many misleading statements on the loan, contained certain terms desirable to the consumer when it did not. Defendant's use of deceit or trickery caused plaintiff to act to her disadvantage. Wherefore, you gotta put the wherefore in your prayer for relief. If you don't ask, you're not gonna get. Plaintiff demands judgment against the defendants as follows. Judgment against defendants as jointly and severely liable for all issues in excess of $1 million. Costs and attorney's fees pursuant to 18 U.S.C. 1964C and relevant Pennsylvania law. Actual and statutory damages for violations of the FDCPA pursuant to 15 U.S.C. 1692K and relevant Pennsylvania law. Costs and attorney's fees. Basically, these are the things you're asking for. Costs and attorney's fees pursuant to 15 U.S.C. 1692K and Pennsylvania law. Rescission of the entire mortgage and note amounting to clear title to property with fixtures as a result of the aforementioned and damages for the unfair and deceptive acts, practices, and damages in the amount of 3 times the interest paid and clear title to the property stemming from the exorbitant interest and judgment against defendants for return of down payment and other payments, as well as interest on the above amount and the cost of litigation as provided in Title 15 USC Section 1601, pre-judgment of and post-judgment interest at the maximum rate allowable by law, compensatory damages, punitive damages, such other further relief available under all applicable state and federal laws, and any relief that the court deems proper, just, and appropriate. Alright, so that's the end of that. And then, let's see here. That's the end of that page. And then at the end of this one, I have to sign an affidavit. So I sign an affidavit, being duly sworn according to law, depose and say the facts stated herein true and correct. And you sign, date it, and I had to sign a verification. There's me, Maureen Souders, hereby wishes statements set forth foregoing complete are true and correct to the best of my knowledge, information, belief. I understand these statements are made subject to the penalties of 18 PACS 4904 relating to unsworn falsification to authorities. Okay, so you have to find the one in your state. Every state's different. Exhibit A. These are my exhibits that I attached to my complaint. First one is the mortgage. I can go through this kind of quickly. Mortgage, the note, and the assignment of mortgage. Alright, there's the mortgage, the note, the assignment of mortgage. Here we go, come on. Adjustable rate rider. It's a lot of paperwork, guys. A lot of paperwork. You gotta get it in the docket. That's where I had my MERS MID number from that. There's my assignment of mortgage, dated October 14, 2011. I don't think it made that trust by the cutoff date. Anyways, Exhibit C. Oh yeah, the trust that my loan is in, explaining that they can't have it because they can't accept assignments until after the cutoff date. Anyway, that's that. Now let's talk about what you need to file with your quiet title action. It's called a lis pendens. It's a separate one. You want to get it ready to file as well. As you can see, it has the case number up there, so make sure you put that on your lis pendens. Make sure the court gets a copy of it, and you take a copy to the county recorder because it has to be in both places. So you want to make sure you have 3 copies of this, one for yourself to keep, one for the court, and one for the county recorder. And basically it says, notice of lis pendens, to whom it may concern. Notice is hereby given of the commencement of and pendency of a suit in the Court of Common Pleas of York County, Pennsylvania, entitled as above, the general object of which is to quiet title of the property owned by Lorraine Souders, a single person, described below against a mortgage recorded within the office of the Recorder of Deeds, York County, to the Bank of America, formerly Countrywide Home Loans, and is recorded in Book 1907 on page 973 as instrument number blah blah blah, and holds title to subject property. And basically this is what you put on your lis pendens. It's pretty self-explanatory. You just have to have a property description on the next page, which you can get. It's probably in your mortgage. Anyway. And then this complaint in the above entitled action was filed to the Office of the Prothonotary on April 30th, 2012. And then I sign it. It gets notarized. I sign a verification, just like I did for the complaint. Ta-da! And then you have your lis pendens and you have your complaint. And those are the two most important things you need to file if you want to, you know, stop your foreclosure in court. So I hope this has been helpful to y'all. If you have any questions, leave comments and I'll try to respond to them, okay? Have a great day, y'all.